I'm so sorry, ma'am. I know you need this medicine, but it looks like it's not covered by your insurance.
Yeah, unfortunately, I had to deny that one.
Wait, who are you?
I'm your insurance company's pharmacy benefit manager. I get paid based on the price of a medicine, and I don't make as much money off this one.
No one should stand between you and your medicine. Visit phrma.org/middleman to learn more. Paid for by pharma.
Seeing an indictment like this, if it were not Donald Trump, I would say, of course, the defendant is going to plead guilty.
Hi, and welcome to another special edition of Amicus. This is Slate's podcast about the courts and the law and the rule of law. I'm Dahlia Lithwick. That is my beat at Slate, and it seems hard to believe it, but around 3 p.m. Tuesday afternoon, Donald J. Trump presented himself at the Wilkie D. Ferguson Jr. U.S. Courthouse in downtown Miami for an arraignment initial appearance in a case known as United States v. Trump and Nada. As is the case with so very many of these trial of the year movie premieres, it's easy to get hyper-focused on all the cars arriving and the photographers and the flashbulbs and the screaming fans in adorable costumes. By Tuesday evening, Trump was headed to Bedminster for a campaign speech, and after his speech, he had a fundraiser with donors who raised at least $100,000 for his campaign, all invited to a, quote, candlelight dinner. Beneath all of this will he, won't he, horse race, drama stuff, this lawsuit stands as a deadly serious moment for democracy, for the rule of law, for national security. And if you read the 49-page indictment filed by Jack Smith in this case, it is amply clear that the focus of this lawsuit is a grave and ongoing threat to national security, one that imperiled U.S. intelligence community and the Defense Department in ways that almost defy belief. So in keeping with our get past the horse race legal analysis, we wanted to dig in on what this case really involves and why it really matters. And we wanted to do that with Ryan Goodman. Ryan is the Anne and Joel Ehrenkrantz Professor of Law at NYU Law School. He served as special counsel to the General Counsel of the Defense Department. His work has made important contributions to the law of armed conflict, human rights law, U.S. national security law. And he is also, above all that, the founding co-editor-in-chief of Just Security, which I hope you are all reading every day. Ryan is exactly the guy who is going to help us sift wheat from chaff. Welcome back to the show, Ryan. I know you're having a busy day.
Thank you. It's great to be back with you.
So I guess we had this initial proceeding in court. There were lots of cameras, very little news. The former president pleaded not guilty. Walter Nada did not plead. Jonathan Goodman was the magistrate judge presiding. And then the president drove off in a big motorcade. Is there anything at all top of mind, having witnessed what happened, or is this already pretty much what we expected, given that we read the indictment last week?
Pretty much what we expected, given the indictment last week, and this is now, in some ways, a part of our lives that we can expect these procedures when they happen with the former president, and it, in all likelihood, will not be the last.
Does it signify at all for your purposes that there were pretty much no real conditions for release, including, I guess, that the president was told not to talk to witnesses, but obviously he and his guy, Walt Nada, work together? I mean, were you expecting any conditions for release, or again, was this just not a surprise?
I wasn't expecting any conditions for release. But maybe that's because I already factored into the equation who we're dealing with. It's a person who would have difficulty fleeing because his face would be known all around the world and he's covered by Secret Service. So I wasn't expecting anything different in that regard. I mean, the one thing that I suppose I did wonder whether or not what might happen is any conditions placed on what he might say in terms of stoking potential violence against, at present, the prosecutor, and if he were to be given a different judge, the judge, if there ever were a fair and independently minded judge, so that I would look for the judge in Miami or the courts in Miami to be making similar statements to him that he received directly in Manhattan, like do not stoke violence, do not do things that could create serious problems for the ability of the courts to administer justice. And that wasn't said today.
I think one of the reasons that we wanted to talk to you in particular after last week's reading of the indictment was that it seems that over the weekend, serious national security people, serious military people, almost across the board, Ryan, took this indictment very seriously. And lots of people, whether it's, Bill Barr, Andrew McCarthy, the editors at the National Review, it just seems like people who think in a deep way about the issues you think about were not apt to bat this away as nothing. So I'm very struck by the fact that this is not necessarily a line between Republicans and Democrats. It's not even a line between people who move in the world of politics and people who move in the world of law, so much as it feels like it's a line between the people who think about the military, national security, and civilians. Is that new? And how much does that matter? And does that tell us anything about how seriously we should be taking these charges?
Yeah, I see that too. There does seem to be a real shift here. And it is about the seriousness of the charges. I think many people might have said, oh, the president didn't do something that grave. He shouldn't be prosecuted for this, the former president, if it did not involve such serious national security matters. And I think that's maybe one of the most compelling parts of the indictment is this long list of document after document after document, 21 of which are top secret classified documents. And then they're so highly sensitive that some of the very code words have to be redacted from the title. And it's like U.S. military attack plans for this, U.S. military vulnerability for that, military vulnerabilities of foreign countries, military vulnerabilities of it. It's just endless. And so to understand that he had that kind of material in his shower and on a ballroom floor or stage is so concerning. And then the other part of it, of course, is that the legal charges don't match all of the seriousness of the allegations, so that the legal charges are purely for his, quote unquote, willfully retaining these documents. And then there is this oddity in the indictment in a certain sense, because the special counsel is definitely alleging that Donald J. Trump also deliberately disclosed some of those documents' information to others that he should not have, though there is no charge for disclosure, which there could have been. I think that's another part that is just so shocking to see that. And it is one of the incidents in which we can understand what the theory of the case is in respect to Donald Trump's motive. So one of those is the sharing of the contingency plans for attacking Iran, and it looks like the motive is simply to settle scores with the current chief and former chief of the Joint Chiefs of Staff and to control the media narrative about Trump, because otherwise he looks bad as his personal image. And that's why he disclosed the Iran attack plans. And so we even have the motive there. So I think it's just so unsettling to reasonable minds. It's not like reasonable minds could disagree. Reasonable minds would see this, I think, in a very similar way. And I think that's part of the shift that we're seeing.
We're going to take a quick break.
I'm so sorry, ma'am. I know you need this medicine, but it looks like it's not covered by your insurance.
Yeah, unfortunately, I had to deny that one.
Wait, who are you?
I'm your insurance company's pharmacy benefit manager. I get paid based on the price of a medicine, and I don't make as much money off this one.
No one should stand between you and your medicine. Visit phrma.org/middleman to learn more. Paid for by Pharma.
Hi there, it's David Plotz, co-host of Slate's Political Gabfest podcast, and I am really excited to announce that we're doing a live show on Wednesday, June 28th. Please join me, Emily Bazelon, and John Dickerson at 6th and I in Washington, D.C. for an incredible night of political discussion, debate, and fun. Slate Plus members, you get an exclusive discount, so if you're not a Slate Plus member, this is a great time to join. Go to slate.com/gabfestlive right now to get your tickets. They are first come, first served. Again, that's slate.com/gabfestlive for more information and to buy your tickets for our June 28th live show in Washington, D.C. at 6th and I. We'll be streaming too, so if you can't make it in person that night, fear not. You can join our virtual gathering instead. slate.com/gabfestlive.
Amicus is coming to you weekly through the month of June, and we're also bringing you emergency episodes like this one when the biggest legal news hits. You can find all of our coverage about the end of this Supreme Court term, because that's also happening, at slate.com/opinionpalooza. Right here on Amicus, we're offering all of our emergency episodes to all of our listeners, rather than holding them behind the paywall as Slate Plus member exclusives. We did that because we want to make sure that we are sharing this vital news and analysis with as wide an audience as possible. But you've got to be quick. Emergency episodes are outside the paywall for a limited time, which is another reason to subscribe to Amicus so you never miss an episode. And as always, we thank our Slate Plus subscribers for making the work that we do possible. More now with Ryan Goodman, founding co-editor-in-chief of Just Security. Given that it seems as though the bulk of the charges are just about sort of mishandling the documents, not trying to, sell them or hand them off, are we ever going to be able to ferret out an actual motive here? I mean, are we ever going to, and it goes to this, perpetual mens rea fog machine that is Donald Trump, that because it's so hard to figure out why he does what he does that affect how he is eventually charged? Because nobody can tell. It doesn't seem to be about money. I don't know if it's about money. It doesn't seem to be about, deliberately engaging in espionage. It seems like he's just being Trumpy.
I don't think it affects the charges that are brought, but I do think it affects how likely it is to result in a conviction, because I think that lingering motive question, if it could be buttoned down, would be very convincing to a jury so that they understand the full picture, they understand the motivation, it all kind of makes sense. But that is somewhat of still a black box. And that's also for the American public to understand. I think if we had a better understanding of motive, then I think it would also be very compelling as a full narrative. And it's still this kind of missing piece. And like you say, I also think that the answer to the missing piece might be it's Trumpy. It's like it's a form of a narcissistic personality in which he just thinks it's all mine. Like he thought he was the state. He thinks he's still the state or the president. It's mine. It's nobody else should have it. So it's just an extension of himself. He likes to have it. It makes him feel powerful, knowing he has it. And then also sometimes it's showing it off as a trophy, as we know that he has done with other things that he's picked up along the way, like Shaquille O'Neal's sneaker. So, and I really think it might be that. And that's why he's showing off his classified map to a political ally. So it makes him feel powerful. And that might be it, but it would be really great to have the evidence of it. And it might be mixed motives, like lots of motives for different things. Yeah.
Does that change anything? The fact that he's just, waving around classified maps because he can, because he thinks they're his, or because he's actually putting people at risk? I mean, I understand what you're saying, that it's going to be really hard to persuade a jury that he, imperils. I mean, the whole framing of this indictment is so painstakingly saying, these are the sources and methods. This is who was burned. This is all the ways in which lives were in danger. Yeah. And if Trump neither knew nor cared, does it change anything?
I think it doesn't necessarily change anything because it's not an essential element of any of the crimes. It just has to prove that he willfully retained the documents. If we do get into a situation, but this is not the present charges, but charges that are based on sharing of information, then it might actually have to be shown that he knew that it could be to the injury of the United States. But as straight up documents, it doesn't have to be shown. But I do think one thing that might easily happen in the trial is we have senior U.S. intelligence officials saying, because he compromised these documents, he then compromised certain highly classified programs, and we had to either drop human sources, drop certain programs. That is the kind of remediation that the government would need to necessarily take once they even just see the photograph of the boxes lined up on the ballroom stage. To be like, well, we can't assume that stuff hasn't been compromised. And it goes to a kind of a heart of the question as to, was there any injury from this? And there's potentially massive injury to U.S. intelligence operations, U.S. national security in that sense. And I think that could be driven home in a courtroom. And then, of course, it can also be driven home for the public at large to even just understand other ramifications of having so mishandled classified information, what it means for like allied relationships with other governments that are otherwise sharing information with the United States. I mean, just to say it as succinctly as I can, there's a prospect this man becomes reelected to the White House. What do those governments think? Like, are they going to be sharing information over the next 2 years with the possibility that this same person who feels the ability to just keep that kind of information in his shower and on the ballroom floor of his public resort might do it again? I think that has serious current day implications.
There's actually a pragmatic question connected to that I've been dying to ask you, Ryan, which is simply, how much is Jack Smith and his team prepared to disclose about this? In other words, it's so clear, as you said, how painstakingly redacted this material is, that there's a way in which it becomes kind of a self-burn the more you explain to the court how much damage potentially has been done beyond just, there were boxes stacked in a badly decorated, chandeliered bathroom. But in order to do that, you are burning your own mechanisms of intelligence gathering and spycraft, and in some sense, in burning your own allies. So how do you navigate that, or does it all just get done in camera?
I think it's one of the key issues to watch as this criminal procedure moves forward, because it's going to be a lot of the pretrial motions will be about this very question. And it's also why I'm very concerned about who is the judge. Is it still Judge Eileen Callan making those calls? Because under the Classified Information Procedure Act, there is a framework that Congress set up to deal with that very tension. And it is to allow the prosecutors to protect some of the information by maybe just allowing them to do a summary of the content of the documents. That's one version of it. But if a judge says, no, I'm sorry, that would not provide the defendant with proper rights because they can't be convicted on the basis of secret information, you have to give up the entire document so the jury sees it and the public sees it or something like that. It's just where they can draw the line on that. They have enormous discretion. That's a big concern. So it was remarkable to me and to many other national security lawyers to see the high-level classification of the documents, that it must be the case that the intelligence community has decided they are prepared to risk some level of exposure at trial. And I do think it probably speaks to the intelligence community's deep concerns about how important this case is for them. And it might also speak to that Donald Trump's action has so significantly burned some of these programs that indeed that's partly why they can share the documents, because it's eroded their significance and value to the United States. So that might be another very plausible explanation for why there's so many documents. And this is like, I'm comparing this to other cases in which I've seen indictments for very similar things under the Espionage Act. This is a remarkable indictment because usually the way that the prosecutors and the intelligence community think of it is that they look for the quote-unquote Goldilocks documents. The Goldilocks documents are the ones that are not too highly sensitive, that it would be exposing deep secrets, and not too low in their sensitivity or classification that it really is not going to compel a jury. Like, you're not going to bring documents marked as confidential. These are not in the Goldilocks zone. They're not like the secret level. They are the tippy-top, top secret, compartmented information, code word, so much so that even the code word has to be redacted. So it's really remarkable in that sense.
It's so interesting because what you're kind of hinting at here is so much of this is going to be fundamentally unprovable because you're proving a negative, right? You're proving, you can't say these are the countries that no longer trust us. These are the programs we've had to shut down. These are the spies who had to be pulled. You can't do any of that. And so what you're describing is a system in which, in some sense, you go to trial with one hand tied behind your back, because all of the stuff that makes this catastrophic is the stuff that can't be in this indictment and, in fact, can't be proven in court.
Absolutely. The only other piece that's maybe different than all the times before, in a certain sense, is that I do think the current leadership of the intelligence community is more likely to be transparent compared to their more recent predecessors. This is in some ways growing out of the Ukraine war, that the head of ODNI and the head of the CIA have been forward-leaning in declassifying information or revealing information in that situation. And I think they very well might be here too, given how enormous the stakes are in this case.
Time now for a short break.
Hey there, Amicus listeners. It's Mary Harris from over at Slate's Daily News podcast, What Next? What Next is a show we make to help you grapple with this question. How do you keep paying attention to the news when it feels like the news is stuck? You know what the Republicans are going to be saying. You know what the Democrats are going to be saying in return. You probably even think you know how you're going to feel about all of it. My short daily podcast is here to help you make sense of things, even surprise you, from fleshing out new angles to uncovering stories that have largely gone unreported. When the news feels a little predictable, I'm here to help you answer what next. So subscribe wherever you're listening right now.
Slate's podcasts cover major news events, from elections to social issues to historic Supreme Court decisions. Our shows also discuss what makes a song a smash, analyze what's going viral, and decode cultural mysteries. If we've become a part of your listening routine, we ask that you support our work by joining Slate Plus. Sign up for Slate Plus now at amicus.com/amicus plus to access all of Slate's content and to support our work. That's slate.com/amicus plus. Let's get back now to my conversation with Ryan Goodman about the case against former President Donald Trump, who was arrested in Miami on Tuesday afternoon. Ryan, I don't want to waste even a nanosecond of your time on the really dumb claims that are being made about, the Presidential Records Act and about the Clinton sock drawer defense. I mean, some of it is just, it's being debunked by the archives themselves, right? But I do wonder if there is any merit to some of the quote unquote legal, put aside the political defenses, right? We love him, but the legal defenses, is there anything that we should be taking very seriously because it's a fundamental weakness of the case that is being surfaced in the sort of doctrinal conversation that's going around right now?
I think the case, to be honest, is airtight, absolutely airtight. The one legal vulnerability that I thought they might have is venue. So if they had brought the case in D.C., they were in maybe deep trouble because it could have been determined that that was the wrong jurisdiction because all the activity took place in Florida. And there's this pending Supreme Court case that many in the audience might know about, strangely titled United States v. Smith, given that Jack Smith is a different Smith, in which the Supreme Court might very well say double jeopardy applies. And if you lose in venue time one, with case one, you cannot then bring it in the proper venue time two. So that was going to be the biggest legal vulnerability I could identify. If I would try to be stretch my mind to think, what is his defense? And the answer might be, there is no legal defense. He committed the crime. It's just that I think it really is that. But if I would try to stretch it, I would think maybe he can claim it is true that they were not his documents, but the defendant thought they were his. It is true that they were not declassified, but the defendant thought that they were declassified and therefore were not closely held national defense information. But it's not true. His own lawyers told him that it was not his. And if he were to try that defense, he'd have to take the stand. That would be a total debacle. Let me put it a different way as well. Looking at all of the prior indictments for retention of national defense information under the Espionage Act in the last 20 plus years, and I've looked at all of them because we wanted to look at like cases and whether or not this case has been treated like. Seeing an indictment like this, if it were not Donald Trump, I would say, of course, the defendant is going to plead guilty. And it is the case that when you have these kinds of allegations, they are prosecuted, and then it usually will end up in a plea deal. But if it ends up in a plea deal, then those defendants, high-powered individuals, often get off with very minimal or no jail time. So that's a tragic part of our legal system. But David Petraeus, Sandy Berger, John Deutsch, guilty, pled guilty. And then because of that pleading, we're going to get no jail time. I say we're going to because John Deutsch also gets a pardon as well. But we're in a situation in which this defendant isn't going to plead guilty. And so that's the oddity of it. But it shows just how strong the case is in a certain sense to compare it against all these others.
I think before I say goodbye and release you back into the wilds of cable news, I want to ask you what seems like a feelings ball question, Ryan, but I always feel like you're the one who helps me stare straight into the weirdness of the moment. And so I'm going to ask it and you can just dismiss it as feelings ball. But I'm very struck again by the ways in which you and I are having a nuanced legal conversation in the midst of a massive political conversation that doesn't actually care about the law. And that, the reason that the defenses are so dumb, whether it's Lindsey Graham saying like, well, people believe it. What am I going to do? I guess it's what it is. Or, the endless, but Biden, but Hillary, the at least the bathroom door locks. You can't lock the garage, right? Like the dumb whataboutism of the moment. And I'm very struck by the fact, as I always am, and I know you and I talked about this around January 6th, like it almost feels as though we have split the universe into politics on one side, and that goes to Trump and his supporters, and law on the other side, and that goes to you and me and people who want to talk about the law. And I want you to help me understand why it is that elected leadership on the side that should be saying from the rooftops, the former president, the guy who is leading the pack for the GOP, was waving classified documents around in his estate and thinks it's fine and there's no such thing as law anymore. We have been so quiet on the politics side. And if I'm correct to posit this as a kind of perpetual foot race between legal consequences and political consequences, how confident are you, feelings ball, that legal consequences win the day when they just don't seem to matter to the other side?
Right. Such a hard question. The one thing I have maybe drawn solace to, so it also suggests that I might be like rationalizing, is that there are ways in which the law can break through some of these information cocoons. And it is the nature of an indictment that gets handed down or a unanimous jury verdict that gets handed down. But even those, of course, might not break through because the indictment is then being politicized and it's being, the groundwork has been laid months and in some ways years before that the DOJ is corrupt and the FBI is corrupt and they're anti-Trump, which is just hilarious to think about that with respect to what the FBI is really about. In terms of how conservative they are and Republican. But I do think that here we are, like we really are at an important milestone of accountability. The legal system is where alternate facts don't work. The legal system is where all of these bogus, made up arguments that are just ridiculous will not withstand scrutiny. And I do have faith that we've gotten this far with an indictment of the former president. It also gives me faith that Jack Smith is going to indict him for January 6th as well, because it shows they're willing to do it. They're not concerned about threats of and blackmail in a certain sense of political violence on the other side of the equation or something like that. They're going to do it. They're going to follow the law and apply it. So we're this far. In some sense, I think it is only a question of if Trump can outrun justice. And the only way he can do it is if the trial takes too long and he becomes president. If he does not become president, and this is a fair trial, I think very high likelihood he is convicted. Question mark. Jurors in Florida, in this particular district in Florida, question mark. But January 6th is going to be brought in D.C. The Georgia case maybe stays in Fulton County. So it's only a question of if he can outrun the law. And that gives me some sense of still faith in the legal system and that we've gotten this far in terms of not just an indictment, but a rock solid indictment that in a courtroom should result in a conviction of this individual, time permitting.
You didn't say question mark Judge Eileen Cannon, but I'm figuring that that's assumed in your list of caveats, yeah?
Absolutely. That's what I mean by a fair process. Yeah. I do not have any faith that she'll carry out a fair process whatsoever. And that's why I say if it's a fair process, because I'm hopeful to some degree that she will no longer be the judge in the case in the coming days and will either step aside or be forced or persuaded by her judicial colleagues to step aside.
Ryan Goodman teaches law at NYU University School of Law. He served as special counsel to the general counsel of the Department of Defense. He is the founding co-editor-in-chief of Just Security, which I am refreshing like a maniac. And he is, and always probably will be, my go-to guy for these national security moments where I think I know what's going on until I talk to him. Ryan, thank you so very much for being with us today.
Thank you so much. It's always a thrill to have a conversation with you.
And that is a wrap for this extra special bonus episode of Amicus, the Holy Cow, This Is Happening edition. Thank you so much for listening in. Thank you so much for your letters and your questions. You can keep in touch at amicus@slate.com, or you can always find us at facebook.com/Amicus Podcast. Today's show was produced by Sarah Birmingham. Alicia Montgomery is Vice President of Audio at Slate, and Ben Richmond is our Senior Director of Operations. We will be back with another episode of Amicus later this week. Until then, hang on in there.